We're going to give it up for Mad, Charlie, and Mr. Kirk.
Show of hands, how many people thought Michael Best was a person? I definitely did. Anybody? Yep. Okay. So it's not, but we'll learn about that here. So if you guys could just do a quick introduction, and then we'll jump into questions.
Great. Well, thanks. I'm Charlie Stevens. I'm one of the more senior attorneys in the Employee Benefits Group here out of the Milwaukee office. Since 2010, I've been doing an awful lot with health coverage, extraordinarily high health claims, the Orphan Drugs Act, and now that employers have to provide coverage that's not limited annually or lifetime, I've been getting more and more calls from brokers where the employer says, what's a laser? And then they're told what a laser is, and then they say, well, what do we do? And the broker says, I know a guy. So I am often referred by brokers, so is Kirk. We have a team of 3 partners at Michael Best that do all kinds of fix-it things with regard to health plans that are out of whack. And quite often it's very, very large health claims.
I have nothing to add to that response.
And by the way, we do have a little flyer about what we do that'll be outside after the session on the self-fund health table if you're looking for more information about what we do and who's on the team.
So I just want to implore all of you to focus in on this session. I know it's hard. The bar just opened and it's the afternoon. And you might think it's boring because it's legal stuff. But I assure you, we spent time getting together, getting ready for this session. I really think it's important no matter what entity you're with. I think you guys are going to learn a lot from this session. So try not to feel like, oh, it's legal stuff. I promise it'll be interesting, and I hope you guys can like it. I am a nerd, so I might find it more interesting than you, but I promise there'll be something for you here. So the first question actually is for Charlie. So when I got introduced to you all and what you do, I was told that you guys are like a Swiss Army knife for essentially eliminating, identifying risk from a plan. So can you talk a little bit about what that means to you in practical terms?
I like the Swiss Army knife comment because that really does describe the fact that we encounter issues and problems, and what often happens is there's something out of whack. The employer didn't know what they didn't know, and we've been there before and we know how to fix it. I don't like the premise that we can eliminate risk, because no one can eliminate risk. Lawyers can't guarantee that, certainly. What we do is we mitigate risk, and we try to identify where the risk is, and we liken it to someone's aiming at you, and how big is the bullet and where is it coming from? So is it a federal agency? Is it an employee claim? Is it the Office of the Commissioner of Insurance? Who is it? And then we try to fix that risk. And sometimes it's a financial risk, such as someone who just found out what a laser is and that they have one that's $1 million.
Well, we all know how I feel about lasers, but maybe not $1 million ones.
What we try to do is we help the employer understand the risks, develop reasonable goals, develop strategies, and implement them. That's what we do.
Do clients work with you under attorney-client privilege?
Oh, certainly. So one of the advantages of engaging the law firm is that we'll have attorney-client privilege conversations. And so we'll say to the employer, what did you do? Or what did you think happened? And we'll kind of walk through it, and there's open discussion. Occasionally and frequently, the broker and other vendors are not part of that conversation. We want to preserve the attorney-client privilege, which is not preserved if you just open it up to everybody. But if you're talking to HR, C-suite management, trying to drill down, manage risks, that's all attorney-client privilege.
And sort of
Kirk, did you have a...
Yeah, it also adds a frankness to it so that you can identify things like, is there a rift that's about to happen, or what is the true lay of the land with regard to what's going on? Because occasionally the left hand and the right hand, even in the company, aren't talking with regard to those types of thoughts. So, one of the comments that was brought up in the last session was get the CFO or the CEO in the room as well. I think that's important in these conversations.
The RIF example is a really good one. I've seen that firsthand where they were making decisions. Some folks were making decisions about a health plan, not recognizing, because obviously people didn't know a RIF was coming, and that had implication. A RIF is a reduction in force for those of you who are new to all the jargon. So a kind of parallel to that is, what's a misconception that you think either employers or brokers have about risk conversations in general when it comes to healthcare?
Well, I just had a discussion this morning with a potential client with an employer. And one of the things that they didn't understand and now do is that it's not unlawful for an employer to directly engage with an employee and say, there's some risk associated with it, but it's not illegal, to say, can we help you address your high health claims in a way that works for both of us? Now, a lot of lawyers think that that's illegal. A lot of brokers think that's illegal. It's not illegal. You have to be careful about how you say things, how you engage with the employee. You have to be careful that the employee doesn't feel under duress. You have to be very careful that you understand and the employee understands that even engaging in these conversations are voluntary on the part of the employee. But there's a misconception that somehow you could have an employee with a very serious health condition or a family member with a very serious health condition, and the employer somehow can't offer to help. But you can.
That's a great example. Kirk, I have a question for you specifically. What compliance or operational risks do you see related specifically to cafeteria plans?
The biggest risk on cafeteria plans, and what we usually catch, honestly, in the deal context, is that you don't have one. These are really easy to skip. They are required. They're required to be in writing. They're also required to talk about everything that you're doing with regard to those pre-tax arrangements. And so occasionally you'll have an employer who started with a POP plan or a premium-only plan. And a couple of years later, they decided, hey, we got a high deductible health plan. We're going to add the HSA element as well. We're going to give folks an opportunity to do a pre-tax contribution on that. Cafeteria plan was never amended. Technically, every contribution that you've made in through the HSA on a pre-tax basis was not permitted. And so, it's making sure you have that in place. Now, am I going to lose sleep over it? I'll tell you I won't. The cafeteria plan not being there has never killed a deal. And I'm going to say that on a global basis, not just my experience. But to the extent you can have these things in place, it helps make you look to the buyer that you've got your house in order. And if you've got your house in order, they may not turn over other stones where you've got other problems.
Yeah. Anything you want to add to that, Charlie? On let's talk about spousal. So you guys saw the title. I know everybody probably jumped in here because we talked about all kinds of funky alternative risk strategies. One is spousal carve-outs. That can be a tricky territory. It's so interesting because we are nervous to talk about some things and then we talk about other things and people kind of have quick, speedy answers for them. So I'm really curious on your take here. How can you guys, or what strategies do you guys have to help employers balance cost and how to control that cost with employee regulations, the relationship with employees, and legal compliance? And that could be specific to spousal carve-outs if you want to talk about that, or just in general.
So show of hands would be useful here. How many are using a spousal carve-out? Okay.
And everyone not raising their hand is being done to you. So, or often that's the case.
Or the bar is taking effect.
Yes.
So it's from a spousal carve-out perspective, I look at the PR element of it first. I'm not seeing it as being as offensive as I did when I got out into practice 20 years ago. There at that point, it was highly offensive to people that you would say, hey, you can't be on my plan if you've got your own plan with your own employer. I think by and large, it's become more commonplace because a lot of people are seeing that and talking to friends about it. That said, I think it's still from the standpoint of, a useful feature here. It does keep people off of the plan, so you're not covering as many lives, and it does have some utility, from that standpoint of keeping costs down. So on the whole, I'm not necessarily as, I guess, offended by them as I was in the past.
That's my experience as well. And there are many different kinds of spousal carve-outs. I mean, some just charge a little more for someone who isn't covered by their employer's plan. Others require the spouse to be covered by their employer plan before they can be covered by the spouse's employer's plan. They're all over the map. So if you don't have a spousal carve-out and you're thinking about having one, understand there's many different varieties of it. So it's something to do some homework on before you just embrace something.
The bigger issue on these is actually when you don't do it right. So for example, if I say that you're going to be subject, in this case, to a surcharge, for example, otherwise, or we try and incentivize employee to go to spouse's plan so that we're not covering you. If you're not also then requiring proof of that other plan, as a part of your program, there was a notice that IRS came back out with, I think it's 2013-54, that's my recollection on the number, but they came out with a notice that basically said, look, if you're not requiring it there, then you're actually incentivizing the individual in an impermissible manner, and so you're subject to an excise tax for it. And by the way, if you fail to self-report on that, now you're subject to interest on your failure to report that excise tax. And so it's important, if you are going to do something where you're incentivizing people in an opt-out to go to a spouse's plan, that you make sure you're doing it in a proper manner. And this then comes back to the cafeteria plan. You also need to, if you're going to have an opt-out payment, make sure that it's in your cafeteria plan.
And newsflash, your TPA does not do that for you. So I've seen a lot of times where people assume that because they put something like that in place and they send an email to, where's my TPA folks? They would have appreciated this call out. But they assume that because you just tell your TPA that you do that somehow they manage all of that and track the proof and get the affidavits, and usually they don't. The comment about spousal coverage, but really all of these strategies, that most of the time when I've seen spousal carve-outs, it's used because we haven't tried anything else, right? We haven't really been thinking about managing risk. It's like a more modern day version of like, well, just raise the deductible. So yeah, it's kind of like well, we can just do this quick, easy thing. And it's definitely not a quick, easy thing. And it doesn't actually solve many problems. So go ahead.
One more thing on it, and then I'll stop doing this. But the other piece where you do offend people, though, in line with the spousal carve-out, is if you then decide to introduce a dependent audit. So, hey, bring me your marriage certificate, bring me all the birth certificates of the dependents that you're covering. Prove to me you should be on this plan. That generally goes over like a lead balloon. And so, one thing to be aware of as you're dealing with the PR elements is if you're going to have these types of things, enforcement of it is one thing you're going to have to consider, and are you truly willing to go that route?
And one more thing while we're playing legal volleyball. A dependent audit of employees is one thing, but I would encourage you to perform audits with your TPA partners and whatever vendor stack you're using for software for eligibility. Not auditing to make sure that your kids are really your kids or your spouse is really your spouse, but to make sure that the eligibility that you have actually matches the eligibility that your plan has and that the vendors have, particularly when you have like HRIS systems feeding into other systems. So different kind of audit, but still useful. A little less offensive, I think, too.
Much.
Okay, this one's for Charlie. What are some of the most common pitfalls employers face when transitioning employees to Medicare, and how can we avoid them? I think a lot of people are really curious about this.
Medicare is great if you have a Medicare eligible individual on your group health plan, but you have to be really careful that you do not incentivize them or impose any duress on them to drop group coverage and to take Medicare. And as the broker Jonathan was up here earlier, his comment was education alone sometimes will get the employee to understand maybe I can go on Medicare and it'll be better for me Sometimes it is. And as a matter of fact, over the last couple of years, it's gotten better because many of you don't realize it, but Medicare did eliminate the donut hole for Medicare Part D, which is a real incentive for people to go on Medicare now, even if they're otherwise eligible for group coverage. What a lot of employers don't understand are the Medicare secondary payer rules. And so if you have someone who continues to be eligible for Medicare, you can't incentivize them, and sometimes that's really difficult to not do. So imagine an employer that has an opt-out arrangement. You opt out of our coverage and you instead go to you just don't take our coverage and we'll pay you X dollars a month for each month you stay off our plan. You can't do that if the person's going on to Medicare, they're Medicare eligible. So what's the risk to the employer if they violate the Medicare secondary payer rules? Well, the difficulty is that employer could, upon a Medicare audit, within a year or two later, get a bill from CMS saying, we paid $75,000 in Medicare claims, and we find out now that you've incentivized the person to get off of your group plan. We think your group plan is primary, and here's how much you owe us, and here's when you must pay us. So we've represented employers in those claims. It's not pleasant at all. So you just have to be careful. Now, the interesting thing is, although you can't incentivize an eligible employee to drop group coverage and go on Medicare, you can have a conversation with that employee. Betty, we understand you've spent decades in our service. We think you're a wonderful person. It's going to be really tough to see you go. But how about a voluntary retirement incentive of insert number? Maybe it's $20,000. And she says, well, this is great. I've not retired before now because I really needed the money. Of course, we need a COBRA waiver. So you get a COBRA waiver in exchange for a retirement incentive, or you simply introduce a broker that says, look, you can go on Medicare Part B, Part D, and get a Medicare supplement, and it's going to be cheaper than COBRA. So you can have those conversations. There's nothing wrong with that. And we orchestrate those all the time. We create the paperwork. We provide the employer the talking points. And what if Betty doesn't think 20,000 is enough? Well, it depends on how big your exposure is. So maybe Betty gets a larger retirement incentive.
Yeah, true story. I've seen one of those. The retirement incentive was 6 figures, but it's because the potential claiming was 7 figures. So in that case, it's worth it. Mm-hmm. Yeah, I think that one's something that people are nervous to talk about. And then this goes back to kind of that whole attorney-client privilege, like having a safe space to ask questions and not feel like you're going to get in trouble for just asking. And I also think it's important to sort of tune out the noise, because it's really hard to know what's real and what's just out there on the internet that people are claiming to be experts. So that's really helpful. Charlie, we'll stick with you on this one. Can you share a story, of course, without any privileged details, even though you don't have to tell a lawyer that, where a small overlooked detail could have become a big liability if it hadn't been addressed, but either you or whoever caught it kind of ahead of time?
A broker contacted me with respect to an employer self-funded plan. And here's the scenario. A particular employee, a production employee, developed heart disease and could no longer work. So he took family and medical leave, and then that ran out. Then the employee had short-term disability for 6 months. And then he had long-term disability. He couldn't work. The doctor said he'll never work at this job. So the stop-loss carrier contacted the company and said, where do you have a policy that says after someone has run out of family and medical leave, they still get coverage? They're not actively at work. How is it that you're continuing to give them coverage? Maybe we don't have to pay for these claims. And they didn't have a policy, but they had a practice. So we drafted correspondence to the stop-loss carrier. We described the practice. We described our position, and the employer got the stop-loss carrier to pay the claims. The employee left employment because he couldn't work anymore. And I said to the employer, did he elect COBRA? Yes, he did. But he needs a heart transplant. Yes, he does. And I said, well, why don't we introduce him to a broker competent in the individual market and have that broker talk with him about, here's some alternative coverage, and in exchange for a payment that in effect would waive all employment claims associated with his employment and his termination of employment and his waiver of COBRA, we give him money. Okay, so we did, and we negotiated with the employee, and the employee ultimately did take 6 figures, but waived COBRA, including, because it was a waiver of COBRA, not only 18 months post-employment, but he was disabled, so it would have the disability extension of an additional 11 months. The employee waived all of that. And by the broker's guess, we saved that employer $1 million.
So this is like the 3rd or 4th time in 2 days that we've talked about leave policies. So does anybody remember the song, Here's Your Sign? Here's your sign, folks. Do not rely on practice at this point. Wonderful that it worked in that case, but you don't have an excuse now. So brokers and employers, the importance of having leave policies that are tight, that work together, and then actually enforcing them is clearly really important. And it's coming from all of those of us who've been in the business for a long time and seen really ugly stuff. So if you don't take anything away from this, which I don't know how you couldn't, but take away that you need to go back and review your leave policies and then review what you're doing to enforce them. Because it worked out beautifully in that case. And if you have a situation where you're going on practice, obviously you know who to call. But at this point, I think everybody should know that those policies are just really vitally important.
That employer does have that policy now. Yes.
I bet they do. And I bet they tell everyone they know about it. Kirk, like similar to that, do you have example stories that you could share, particularly around high cost claimants? I know we don't like describing people that way, but I think a lot of times we're looking at sort of the number on the spreadsheet, the people who are incurring a bunch of cost.
So it's a little bit different on that. It's kind of it took a left turn, right? So it was a high cost claimant that triggered the initial conversation. The patient and his, well, 2 patients, right? The employee and his spouse were both in an auto accident. Really, really bad auto accident. It was unclear at some point whether or not they would walk again. And that wasn't the worst of the injuries that they suffered in this. So really high costs. And we were able to get them on the individual market and to get them all the care that they needed and to move on. And they were very thankful for the whole process. It was a win-win, which is what you look for in these things. But as we were unturning the stones in it, what we found out was that the employer in this case was part of another group of similarly situated industry. And they had created a multiple employer welfare arrangement on a self-funded basis, and they were running it completely wrong. And so the project went from getting the individuals on an appropriate level of coverage to actually unwinding their entire plan relationship because they couldn't do what they were doing, and then setting them up in a proper way. And I don't believe that the broker who set that up is in the room.
If they are, they're not raising their hand.
They are not.
So, Charlie, we talk about all of these different strategies to sort of impacting costs, because we can't eliminate it, but impacting risk and cost. What, in your opinion, makes them succeed or fail in practice?
Well, sometimes the employer has certain ideas that they have to kind of set aside. Thinking outside the box really makes for a much better conversation. occasionally the employer will say something like, we know that we have high health claims, so we've taken great pains to not know who it is because we don't want any exposure under the Americans with Disabilities Act. Should we inadvertently discipline them or we think there's too much risk here or there, or they're open to discussion about one solution they've heard about but nothing else. Very often, we help the employer pick their battles. We throw out ideas, we brainstorm. We don't want to have this conversation without the group broker on the call. And sometimes we have the group broker on the call, the employer, the lawyer, obviously, and then also sometimes a broker who's strong in the individual market. If we're trying to find alternative coverage for somebody, we never send them to healthcare.gov. I think saying, go find something, and if you find it and it seems to work for you, that'd be great. We don't do that. What we try to do is introduce someone who's competent finding individuals coverage and to do the hand-holding and to manage the transition from group coverage to individual coverage. And, to hear, well, if you like your health plan, you can keep it. It's not like that anymore. I mean, it's gotten very much more HMO-like. So sometimes it comes down to the zip code of where the individual is as to whether there is a win-win. So we really do need to drill down, think outside of the box, but do your homework. Those are the things that make things most successful. And if that doesn't present itself as an option, then you go to plan B and you identify that, or plan C, but be open to the discussion.
Kirk, anything to add to that?
No.
If you could give employers and brokers one piece of advice to make risk conversations more productive, what would that be?
Well, a large part is what I just mentioned, but the concept really comes down to kind of trusting our experience in how we've managed these things. We go everywhere from very, very risk-averse employers. I had one that asked me if I could guarantee, and I was about to say no, and then he said, can you guarantee you'll keep me out of ERISA prison? And I said, yes, I can guarantee that. You will not go to ERISA prison.
I asked Charlie where that was. I'm just curious.
Well, it doesn't exist. So I heard someone say Florida. I guess that. Yeah. If there was one, that's where it would be. We have a lot of different options. So, a lot of people come to us and say, we like your approach. And well, what approach is that? We're the Swiss Army knife. So we could amend your plan to exclude J-code drugs or orphan drugs, or we could do that. Most employers don't want to do that. They want the employee to get the care they need. There's a recent Supreme Court case from just a couple of years ago. Did you know that it's legal for an employer to move all of its kidney dialysis coverage to out-of-network? Very few people know that. We had some big cases where that was really meaningful. So we raised that with a TPA that rhymes with Mantham. And they said, we won't do that because it violates our network contracts. But at least we had that as part of the conversation. Occasionally we'll provide an incentive to the employee to retire, as we described. Occasionally we'll do the direct approach with the employee, introduce another broker competent in the individual market. They'll find something that's a win-win, and we script it for the employer, and we say, have this 30-second conversation. This is voluntary, this is confidential, you have an opportunity others don't have. Don't tell everyone in the company, because we can't do this for everyone, but we can do it for you. We have someone to introduce you to. If you'd like to explore whether a different carrier can cover your claims, we could save some money. We can share that money with you. How would you like first dollar health coverage? If you don't want to explore it, that's up to you. If you explore it and don't want to take it, that's up to you too. No problem with that. The best way to mitigate risk in situations like that is to have a happy employee at the end of the day. And very, very often with that approach, if we think it might work, we engage with the employee. They never know we're around, and then the worst thing that happens is the employee says, "You should have come to me sooner."
Yeah. I mean, I think the sort of theme of all of this is that you just need to start having the conversations and with people who are qualified to have those conversations with you. I was thinking about Nikhil's presentation yesterday about all the fringe stuff in the industry. And so many people think that like creative risk strategies are fringe, but as we can see, that's not the fringe part of this industry. So we just need to not be so scared, I think, to have some of these conversations and realize that there are strategies, but also make sure that we're getting direction from people who are qualified and understand the applicable regulations or notices or laws that speak to those. I kind of wanted to, before we go to Slido questions, since Ben isn't harassing me yet about it, since you guys have the mic and we got through our questions really efficiently and you've been here listening to a lot of the sessions, are there any comments, suggestions, ideas that you guys wanted to comment on over the last 2 days while you have this opportunity to talk to this great room of brokers and employers? I guess, Charlie, you want to start?
Well, I'll let Kirk think about it while I provide my comment. I really like the presentation before us on what brokers think, because quite a bit of the time we're introduced, the broker is showing us to be an additional resource that they have, that they want the employer to be aware of. Whether the employer engages us or not, we're happy to have a conversation with that employer and be introduced to them and see if we can offer value. And so to hear what we heard just a short time ago was really encouraging, because broker relationships are really strong referral sources for us. So I like that. And I know it's easy for me to say with you next to me, Madeline, but I liked your presentations too.
I did not pay him to say that. It was genuinely an off-the-cuff question.
We speak the same language to a large extent. So,
the thing that has resonated that I hope everyone takes away is that it is not a September to December game or the last 4 months of your plan year. Frankly, some of the stuff that we do would be much easier if we were starting that conversation, even though we can't explore maybe the individual market in the beginning part of the year. But to identify those problems early really maximizes the ability to come up with a solution that will work for all parties. And so I think you can't view healthcare as a 3 or a 4 month project every year.
Yeah, wonderful. Well, I think, Ben, we are ready for Slido. We were extremely efficient with our questions. So are you going to join us?
Absolutely.
All right.
So, and I've gotten these words directly from Charlie, that he would spend an hour with any employer for free. He's told me that on record. All right, so.
if I could qualify that, Ben.
Dang it.
What I would really like is if I'm being introduced by a broker, maybe 15 minutes with a broker to ask some limited questions to make sure we can offer
Align.
value.
Yeah.
So, for example, I would ask, calendar year health plan, insured versus self-funded. Are you trying to take them self-funded? What's the risk? Is it a rocky renewal? Is it a large laser? What can you tell me about the individual? Is it the employee or a family member? Do you have a provider system that you can tell me about? What zip code does the person live in? I can do some preliminary analysis and try to figure that out.
Yes.
And so that is what we would like to do. The broker is typically, if we're introduced by the broker, that's where we rely on the broker to do some initial triage. So where we don't really offer much in the way of value, if there's nothing obviously broken, is where you may have a self-funded health plan. There's 200 people, 200 employees on the plan. 3 of them hit the specific attachment point in a year, but only barely. And the employer thinks we can offer value. We solve big problems. The larger the laser, the better we look and the happier the employer is with us. And if they're just a function of being self-funded, it's harder to actually fix that. There are fewer fixes.
And I like what Matt said earlier, where again we've repeated this theme a lot, that there's no silver bullet that is just going to take all our problems away. It's a lot of engagement, education, and just the hard work of managing change. And so they are a part of it, obviously, but it's not everything. We need to manage risk throughout the year and do the claims things, do the population management, all that. Okay, so here's a question. Where should employers look to learn more, especially in terms of what we can and can't do, so we don't find ourselves in uncomfortable conversations? And said a different way, I think the heart behind that is that I don't know enough to even broach the subject. And so because of my unknowing and, doing something that's going to be not compliant or whatever, I'm just not going to bring up the subject at all, and we're just going to leave it alone because it's too scary, too crazy, whatever. So how would you respond to that?
I mean, without the shameless self-promotion, you should be talking to counsel with regard to scripting it, because there are lines, they're easy to cross, but there is a path to get through it. And so it part of it really depends on us being, to steal from Ted Lasso, because I love this scene, but the be curious piece of it, we really need a lot of information with regard to what we're dealing with to be able to figure out what that best path is and where the big bullet is coming from. Because if it's coming from the employee's dissatisfaction, that's a lot different than coming from the EEOC claim they've already got pending.
Right.
Well, and we don't charge a success premium for what we do. We charge it by the hour,
right,
and we itemize to the 10th of the hour. So if there's an employer that thinks, well, maybe it's time we got an employee benefits attorney, that they can engage us, and then we charge based on what they want to talk to us about.
Yep.
And sometimes there is something that keeps them awake at night, and we have a brief conversation, and maybe they sleep better.
Can I just add something for the next question? From a resource standpoint, so if you're not sure if you need counsel and you're just trying to understand, my biggest caution so if he's the guy that people call when it's a legal mess up, I know a guy, I'm the I know a guy on the operations side. And I will tell you that sometimes it's just an operational problem and it's not necessarily a legal problem. So be more discerning about where you get your information from. Ask more questions. You may need counsel, but you may not. But just be more discerning about where you're getting it. Sometimes it's not ChatGPT, or it's not just asking your broker friend. Sometimes you might need to reach out and find resources. Obviously, you're here today. The panel of speakers and resources that are here, I know we would all be happy to, answer questions or provide referrals if you need things. But just think about where you're getting your information, but maybe looking for those resources. Some of the industry groups and associations have resources that are publicly available. Those you can rely on. There's publications by firms, like Michael Best even has some on their website. So just think about where you're getting the information, but sometimes, you can do a lot of your legwork yourself before you figure out if you need counsel or not.
So this is just asked, what do you charge per hour? What is the average number of hours you spend for these examples you mentioned? Said a different way, when is it going to be the most worth it? You sort of already said an example. Well, if you have 3 claimants that hit their spec and just barely, you got to just manage your risk on the claim side. I mean, that's what that is. And so I know it depends is a cop-out, right? But it depends. Are you fully insured? Are you self-funded? What is the manner of the claimant? Are you going to be able to mitigate the risk? Is it a guaranteed claim? Over $250,000? Well, now we're talking, right? And how would you add on to that to potentially make sure that would be something worthwhile?
We welcome any conversation from an employer. We staff it based on what we think the best approach would be and the least expensive in terms of legal fees. We look at it from the point of view of what does the situation call for, and how do we best provide resources that are worth it. I have to say that when it comes to high health claims, I'm not aware of another firm that does what we do. We typically talk in terms of value and legal spend total. Sometimes we can save someone $300,000 or $400,000 or $1 million, and the legal spend is $15,000. Or sometimes it's 30 and we don't find a solution no matter how hard we've tried. But at each step of the way, the employer is aware of what we're doing wants us to continue, and it's worth the legal spend. This is some inside baseball among our law firm, but I'll share, even though I haven't been to the bar yet.
Yes, he has.
I have passed the bar, I'll put it that way. I had a brand new client. We were still in the process of establishing a nice relationship, but he wanted to test me. And he said, here's an issue I have. And he gave me the most convoluted legal question he could possibly give me. And it's this, and it's this, and then this came in, and then the guy shouldn't have enrolled in Medicare Part B, but he did, and then this came, and this happened, and what do you have to say? And I said, well, I think what I'll have to do is I'm going to go to our law library. I'm going to take some books off the shelves. I'll have my legal pad. I'll be writing down some cases. And then I'm going to go back to my office and I'm going to dictate a memo, and my secretary will type it up. It'll be reviewed. You should have it maybe a week to 10 days from now. Or I can just tell you the answer. We don't have a law library. Here's the answer. I told him the answer immediately. And what I'm trying to get at is, don't ask me what my hourly rate is. What I'm trying to do is say, we offer value. We charge for the value we offer. My hourly rate is higher than Kirk's. Julia is a member of the team, and her hourly rate is even lower. Julia just made partner, but she's still charging associate rate. So if I think Julia can answer your question, we're going to have Julia give you a call. But yeah, Julia's happy to give you a call. I do have a somewhat higher hourly rate. If you want to meet me at the bar and give me your card, I'll give you mine and I'll tell you my rate.
Well, I'll just say
Deal.
to this, if their whole purpose is helping employers contain costs, I don't think these are the people that are trying to screw you on an hourly rate, just having been in the business for a
And I
minute.
know Charlie has worked with dozens and dozens and dozens and dozens and dozens and dozens of employers, helping them with this risk and manage the difficult and tricky conversations of high-cost claimants coming off the plan. And so that's why you hire him. And so, yeah, that's great. That's all the time we have. Thank you so much, guys.
Thank you so much.
Thank you. Thank you.